Related industries like gun stores, liquor licensees, junkyards, travelers and their belongings at international borders, the border search exception, and cars at vehicle checkpoints and roadblocks, like those DUI checkpoints we mentioned. The rationale is usually a balancing act. The government's special need versus the individual's often reduced expectation of privacy in these specific contexts.
Then we have D for stop and frisk, or Terry stops, which we covered in detail earlier, but it's important to remember it as a key warrant exception, a brief, limited detention and search based on reasonable suspicion, not probable cause. Now, as again for the plain view doctrine, this seems straightforward, but what are the exact requirements for police to seize something they see?
Okay, under the plain view doctrine, police may seize items that are in public view without a warrant because, well, there's no reasonable expectation of privacy in something openly exposed to the public. For items in private view, like inside someone's home or car, there are 3 strict requirements that must all be met for the seizure to be valid under this doctrine. 1, the police are lawfully on the premises where they can see the item. For example, they have a warrant to be there for something else, or they're there based on consent or exigent circumstances. 2, the criminal nature of the items is immediately apparent, meaning they have probable cause to believe it's contraband or evidence just by looking at it without needing to investigate further. And 3, the officer has lawful access to the items themselves. They can't break down a door just because they see something illegal through a window. If any of these 3 are missing, the seizure is invalid under plain view. For example, if police are lawfully inside a home executing a search warrant for guns and see a bag of what is clearly identifiable marijuana on the coffee table, they can seize it. But if it's inside a closed drawer, it's not in plain view.
P is for the automobile exception. This is a big one, given how often cars are involved in crimes. How broad is this exception, really?
It's quite broad, yeah. This exception allows police to search any part of a car, including the trunk and any containers within it, like bags or boxes, if there is probable cause to believe that the car contains contraband or evidence of a crime. The rationale here is twofold. The inherent mobility of vehicles, they can be driven away easily, and the generally reduced expectation of privacy people have in their cars compared to their homes. However, a crucial limitation you need to remember. This exception does not permit the warrantless entry of a home or its curtilage, like a garage or driveway right next to the house, to search a vehicle located therein. So police can't break into your garage without a warrant to search your car parked inside, even if they have probable cause for the car itself. The home's protection takes precedence.
A for consent. This seems like the simplest way for police to search, just ask. But what makes consent truly voluntary? Can they trick you?
Yes, voluntary consent can eliminate the need for probable cause or a warrant entirely. Consent is considered voluntary if, based on the totality of the circumstances, it is given without the threat of harm, compulsion, or the false assertion of lawful authority. The government has the burden to prove it was voluntary, not coerced. A key detail for the bar exam is that a government agent may pretend to be someone else to obtain voluntary consent, like an undercover officer asking to come inside. This kind of deception doesn't automatically make the consent involuntary as long as there wasn't coercion involved. For third-party consent, someone else can consent to a search of your property, only if, 1, the third party has actual or apparent authority over the area or item to be searched, like a roommate consenting to search common areas but maybe not your private bedroom, or 2, the suspect assumed the risk of the search by getting rights to the third party with respect to the property. It's about shared control or access.
C for exigent circumstances. This sounds like an emergency situation where there's simply no time to run and get a warrant.
That's exactly right. The government must demonstrate both probable cause, that evidence for a suspect is present, and the existence of exigent circumstances based on the totality of the circumstances. This is a high bar, and a critical limitation is that police may not create the exigency by threats or conduct that violates the Fourth Amendment. You can't, for instance, illegally try to break down a door, hear shuffling inside, and then claim that shuffling created an exigency justifying entry. Common types of exigent circumstances include hot pursuit, where police are actively chasing a fleeing suspect, especially a felon, and can follow them into a private building without a warrant. An emergency also arises when there is reasonable apprehension that a delay in getting a warrant would result in an immediate danger, like 1, the destruction of evidence, 2, a threat to the safety of the police or the public, or 3, a threat that a suspect will flee before a warrant can be obtained. This is about genuine, pressing need based on the facts at the time.
And finally, E for special government purpose or special needs searches. These seem to be another category that balances individual rights against some broader public interest, similar to administrative searches.
Yes, these are another category often related to administrative searches, where the primary purpose is not standard criminal law enforcement. The state interest must be a real, current, and vital problem that can be effectively addressed through the proposed search. Think of things like mandatory drug testing for railroad employees after a major accident, or maybe random drug testing for student athletes in public schools. The government's special need must be balanced against the privacy interests at stake and the character of the intrusion. These searches are generally upheld when the primary purpose is regulatory or safety related, not just gathering evidence for criminal prosecution.
Okay, we've covered a lot of ground on the Fourth Amendment's application to searches and seizures and its many, many exceptions under said spaces. Now let's circle back to the exclusionary rule, specifically the fruit of the poisonous tree doctrine, which extends its reach, and then we'll review even more exceptions to that doctrine.
Right, the fruit of the poisonous tree doctrine is a direct extension of the exclusionary rule. Its core concept is that the exclusionary rule applies not just to the evidence initially seized as a result of government illegality, what we call the primary evidence or the tree, but also to secondary derivative evidence resulting from the primary taint, the fruit. So if the initial illegality is the poisonous tree, say an illegal warrantless search of a home, then all evidence that grows from it, like a confession obtained after confronting the suspect with the illegally seized evidence, or maybe witnesses discovered because of information found during that illegal search, is considered fruit that must also be excluded. If we connect this to the bigger picture, the fruit of the poisonous tree doctrine really serves to fully deter unlawful police conduct by preventing the government from benefiting from any evidence, direct or indirect, that flows from their initial constitutional violation. It aims to put the police back in the same position they would have been in had no illegality occurred in the first place.
So it's about making sure the police don't get any advantage from their misconduct, preventing them from doing indirectly what they can't do directly. Makes sense. But of course, just like the exclusionary rule itself, there are key exceptions to the fruit of the poisonous tree doctrine, which, again, often come up on bar exams.
Indeed. There are several important ones. First, the inevitable discovery rule. Evidence that is fruit of the poisonous tree is still admissible if it would have been discovered in the same condition through lawful means anyway. The government has to prove this by a preponderance of the evidence. For example, if police illegally search a trunk and find a body, but it's proven that a lawful search team with dogs was already systematically searching that exact area and would have inevitably found the body moments later, the evidence might be admitted under this rule. Second, the independent source doctrine. Evidence is admissible when it was discovered in part by an independent source unrelated to the tainted evidence. So, if an illegal search reveals evidence, but then a completely separate, lawful investigation independently uncovers the very same evidence, it can be admitted. The legal discovery wasn't tainted by the illegal one. Third, the attenuation principle, sometimes called dissipation of the taint. Evidence is admissible when the passage of time and intervening events purge the primary taint. The connection between the initial illegality and the discovery of the evidence becomes too weak or remote to justify exclusion. For example, if a suspect is illegally arrested but then released, comes back voluntarily days later after talking to friends, receives Miranda warnings, and then confesses, the confession might be attenuated from the illegal arrest.
And then there's the big one, the good faith exception, which sounds like it could potentially swallow the rule if not for its own specific limitations. What's the rationale behind allowing evidence when police acted in good faith?
It's a significant limitation on the exclusionary rule. Yeah, and it shows the court's desire to limit the rule's application to only those situations where exclusion actually deters police misconduct. Evidence is admissible when the police relied in objective good faith on a facially valid warrant that was later found invalid, or on an existing law that was later found unconstitutional. End quote. The idea is that if the police genuinely believed they were acting lawfully, and the error was made by a judge issuing the warrant or the legislature passing the law, then excluding the evidence doesn't really deter police misconduct, because the police didn't do anything wrong. However, this exception has crucial limitations. It does not apply in several situations. If no reasonable officer would rely on the affidavit underlying the warrant, e.g., it's a completely bare-bones affidavit with no real facts. If the warrant was defective on its face, for example, it fails to state the place or items with any particularity, if the warrant was obtained by fraud, the officer deliberately lied to the magistrate, if the magistrate wholly abandoned his judicial role, basically just rubber stamping warrants without review, or if the warrant was improperly executed in some flagrant way by the police. These are all situations where the police themselves were at fault, or at least should have known better. So deterrence still makes sense.
So it's not just a blank check for police. There are clear boundaries where the officer's subjective good faith isn't enough. Are there any other important exceptions to the fruit of the poisonous tree we should cover?
Yes, a few more quick ones. Isolated police negligence is generally not enough to trigger the exclusionary rule. The Supreme Court has clarified that the police conduct usually needs to be sufficiently deliberate or culpable so that excluding the evidence can meaningfully deter it. Simple, isolated mistakes often won't lead to exclusion. As we noted earlier, and it's worth reiterating because it's a coin-trick question, the exclusionary rule also does not apply when the police merely failed to knock and announce their presence before executing a warrant. And finally, the exclusionary rule does not apply to a witness's in-court identification of defendant. The rationale is that the witness's memory of the defendant is considered an independent source, not typically the fruit of an earlier unlawful search or seizure, as long as the identification procedure itself wasn't unduly suggestive.
That makes sense. The witness's memory isn't tainted in the same way physical evidence might be. And what about when an exclusionary rule violation does occur and the evidence should have been excluded? Is it always an automatic new trial if that evidence got in?
Not necessarily. Even if a court finds an exclusionary rule violation occurred and the evidence was wrongly admitted, it can refuse to order a new trial if the error is deemed harmless beyond a reasonable doubt. This means the appellate court is convinced that the illegal evidence did not contribute to the verdict, perhaps because there was overwhelming other untainted evidence of guilt. The burden is on the prosecution to prove the error was harmless.
All right, let's transition now from the Fourth Amendment search and seizure rules to the Fifth Amendment, focusing specifically on the privilege against compulsory self-incrimination. This is where we get into that deeply ingrained right you have not to be forced to testify against yourself, a real cornerstone of our adversarial system.
That's right. The Fifth Amendment states quite clearly, no person shall be compelled in a criminal case to testify against himself. This privilege is fundamental, and through the 14th Amendment's Due Process Clause, it applies to the states as well. It's crucial to understand that person here means an individual or a natural person. Artificial entities like corporations, partnerships, or labor unions do not qualify as persons for this privilege and thus cannot plead the Fifth to avoid producing documents or testimony. This is an important distinction for business entities and their representatives.
Okay, so a company can't plead the Fifth. And what's the scope of this privilege? When exactly does it apply? Does it cover everything?
It applies quite broadly, actually. It covers any proceeding, civil or criminal, formal or informal, if there is a reasonable possibility that the answers would incriminate the defendant in a future criminal proceeding. So, it can be invoked in a civil deposition, a congressional hearing, or a preliminary criminal hearing, not just at the criminal trial itself. However, and this is a key limitation, it applies only to testimonial evidence. This includes things like oral testimony or the very act of producing a document if that act itself implies the existence, custody, or authenticity of the document. It does not protect non-testimonial physical evidence, such as being compelled to provide blood samples, urine samples, or breathalyzer samples, or being forced to provide handwriting or voice exemplars, or even stand in a lineup. You can be compelled to provide those things because they are considered physical evidence, not testimony that reveals the contents of your mind or beliefs.
That's a critical distinction. It protects your words, your thoughts, the content of your mind, but not your physical characteristics or required actions.
Okay. And when can this privilege be waived or maybe overcome by the prosecution? Well, a defendant waives this privilege entirely by taking the stand at trial and answering the prosecution's questions on cross-examination. Once they start testifying voluntarily about a matter, they generally can't selectively invoke the Fifth Amendment regarding that same matter. Similarly, a witness in any proceeding waives the privilege as to a particular subject matter if they disclose self-incriminating information in response to a specific question. They can't then refuse to answer follow-up questions reasonably related to what they already disclosed. However, the prosecution may compel incriminating testimony, even if the privilege would otherwise apply if it grants the witness immunity.
What are the different types of immunity, and how do they differ in the level of protection they offer?
There are two main types. The most common is use and derivative use immunity. This is the minimum grant of immunity required by the Constitution to compel testimony over a Fifth Amendment objection. It prevents the use of the witness's compelled testimonial communications against that witness in a criminal proceeding. And it also prevents the use of any evidence derived directly or indirectly from that compelled testimony. So if you testify under this immunity, the prosecution can't use your words or anything they learn solely from your words against you in a later criminal case. Then there's transactional immunity, which is much broader. It prevents the prosecution of the witness for any crimes related to the witness's testimonial communications. This is often called blanket or total immunity because it acts as a complete bar to prosecution for the specific transaction or criminal episode about which the witness testifies, regardless of whether the prosecution finds independent evidence later. A grant of immunity, whether use or transactional, is powerful. It typically precludes another U.S. jurisdiction, like another state or the federal government, from using the compelled testimony or its fruits to prosecute the defendant.
Okay, now here's where it gets really interesting, the part everyone knows from TV shows. Miranda warnings. This is probably the most common context where the Fifth Amendment really comes to life in police interactions, specifically during interrogations. What's Miranda's core rule, and maybe what's the why behind it? Why did the court feel these warnings were necessary?
The core rule, established in a landmark case, Miranda v. Arizona, is that any incriminating statement obtained as a result of a custodial interrogation may not be used against a suspect at a subsequent trial unless the police inform the suspect of his Miranda rights before the interrogation began. The Supreme Court's reasoning was rooted in the inherently coercive atmosphere of police-dominated interrogations. When a suspect is both deprived of their freedom in a significant way, that's custody, and being questioned by law enforcement, that's interrogation, the court recognized that subtle and not so subtle psychological pressures can easily overbear a suspect's will and compel them to speak when they otherwise wouldn't. The warnings, the right to remain silent, right to an attorney, etc., are designed to counteract that inherent coercion, to ensure any statement made is truly voluntary and not compelled, thereby safeguarding the Fifth Amendment privilege against self-incrimination in that specific setting.
So both custody and interrogation have to be present for Miranda warnings to be required. How do we define those two crucial elements? What counts as custody? What counts as interrogation?
Okay, custody, for Miranda purposes, is defined as either a formal arrest or a restraint of freedom equivalent to an arrest. The key question, again, is an objective one based on the totality of the circumstances. Whether a reasonable person in the suspect's position would believe that she could leave. It's not about the officer's secret subjective intent or the suspect's own subjective feeling of guilt. For example, being questioned down at the police station is not automatically custodial. If you drove yourself there voluntarily, were told you were free to leave at any time, and weren't physically restrained or treated like you were under arrest, you might not be in custody for Miranda purposes. It's always a fact-specific inquiry. Interrogation includes not just express questioning, but also any words or actions on the part of the police that the police should know are reasonably likely to elicit an incriminating response from the suspect. This is the functional equivalent of questioning. It's not just direct questions. It can be a statement by an officer designed to provoke a confession, like, gee, it would be terrible if that missing gun fell into the hands of a child.
And what about voluntary statements? If someone just blurts something out spontaneously or walks into the station and confesses without being questioned.
Voluntary statements are not protected by Miranda and are generally admissible. Miranda only applies to statements obtained as a result of custodial interrogation. A statement is truly involuntary, violating due process, if, under the totality of the circumstances, it was coerced by the police, meaning physical force, threats of harm, or improper promises that overbear the suspect's will. This is a higher standard than a mere Miranda violation, a crucial nuance for the bar exam. Deceit or fraud by the interrogators does not itself make a confession involuntary under the Due Process Clause. So if police lie about having evidence against the suspect, that trickery doesn't automatically make a resulting confession coerced, as long as no threats or improper promises were involved.
So, assuming we have both custody and interrogation, what exactly must be said to comply with Miranda and when? Is there like a magic phrase they have to recite?
The warnings need not be recited verbatim from the Miranda opinion, but they must reasonably convey the required information. They must be given before interrogation begins, and generally must be given again if an interrogation is stopped for a long time and then resumed later. The warnings must clearly inform the suspect of the right to remain silent, that any statement can be used against the suspect in court, of the right to an attorney during questioning, and that an attorney will be appointed if the suspect is indigent and cannot afford one. This ensures the suspect understands their fundamental rights before any questioning starts.
Okay. What if the suspect says they want a lawyer? How clearly do they have to say it, and what are the specific consequences for the police once they do? This seems like a point of frequent confusion.
It is. A suspect must make a specific, unambiguous statement, asserting her desire to have counsel present. Mere silence is not enough. Nor is an ambiguous or equivocal statement like, maybe I should talk to a lawyer. They have to clearly say something like, I want a lawyer. Once this right to counsel is clearly invoked, all interrogation must stop immediately regarding any crime and cannot resume unless one of two very specific things happens. One, the suspect voluntarily initiates further communication, exchanges, or conversations with police, end quote, which includes spontaneous statements not made in response to questioning. Or two, there has been at least a 14-day break in custody, meaning they're released back into the general population, and fresh Miranda warnings are given. The police cannot try to badger or persuade the suspect to change their mind once they've asked for a lawyer.
So the police cannot just reinitiate questioning after a short break if the suspect has unambiguously invoked their right to counsel during interrogation. That's a bright line. What if the suspect just wants to remain silent but doesn't necessarily ask for a lawyer?
Similarly, to invoke the right to silence, a suspect, quote, must make a specific, unambiguous statement asserting her desire to remain silent. Again, mere silence in the face of questioning is not enough. The police aren't required to guess the suspect's intentions. If this right to silence is clearly invoked, the interrogator must scrupulously honor this right. This means they must stop questioning immediately about the crime under investigation. However, unlike the invocation of counsel, the police might be able to reapproach the suspect after a significant period of time has passed, give fresh Miranda warnings, and inquire about a different crime, as long as the initial invocation of silence was respected. If the suspect later indicates a desire to speak about the original crime, subsequent interrogation is lawful if the suspect is not coerced and Miranda warnings are given again. The rules are slightly less rigid than for invoking counsel.
Are there any situations where Miranda warnings aren't required at all, even if there seems to be custody and interrogation, maybe due to overriding public concerns?
Yes, there are a few key exceptions you need to know. The most significant is the public safety exception. If public safety is at risk, police can ask questions reasonably necessary to secure public safety without giving Miranda warnings first. The classic example is asking a just-arrested suspect, "Where's the gun?" if they believe a weapon was discarded nearby that could harm someone. Also, police are generally not required to give Miranda warnings before asking routine booking questions like name, address, date of birth, height, weight, etc., as these are considered administrative, not investigative. And interestingly, if police are acting undercover and the suspect doesn't know they're talking to a government agent, Miranda warnings are not required, even if the suspect is technically in custody, like in jail. Why? Because the coercive police-dominated atmosphere that Miranda seeks to counteract is simply not present if the suspect believes they are speaking freely to a fellow inmate or a friend.
That makes perfect sense. The element of police coercion, which is the whole point of Miranda, is missing in those situations. And finally, a suspect can waive their Miranda rights, right? They can agree to talk. What are the requirements for a valid waiver, and who has the burden of proving it?
Yes, a suspect may waive Miranda rights, but that waiver has strict requirements to be valid. The burden is squarely on the government to prove by a preponderance of the evidence that the waiver was made knowingly and voluntarily. Knowingly means the suspect understood the rights they were giving up, and voluntarily means it was not the product of police intimidation, coercion, or deception regarding the rights themselves. A critical detail for the bar exam. Silence alone is insufficient proof of waiver. The waiver must be affirmative, either an express statement, yes, I'll talk, or sometimes an implicit waiver demonstrated by a course of conduct after receiving the warnings and indicating understanding, like immediately starting to answer questions.
All right, let's talk about the fruits of a tainted confession. We know about the fruit of the poisonous tree for Fourth Amendment violations, where illegally obtained evidence generally taints derivative evidence found as a result. But what happens when a confession itself is obtained in violation of Miranda? Does the same broad fruit doctrine apply? This is a crucial distinction you need to grasp.
This is a key distinction, absolutely, from the Fourth Amendment's broader fruit of the poisonous tree doctrine. For Fifth Amendment Miranda violations, the rule is generally more limited. Quote, derivative physical evidence obtained as a result of a non-Mirandized confession is generally admissible so long as the confession itself was not coerced under the due process standard, meaning it wasn't truly involuntary due to threats, force, etc. So, Let's say police question a suspect in custody without giving Miranda warnings, and during that unwarned interrogation, the suspect tells the police where they hid the murder weapon. If the police then go and find the gun based on that statement, the unwarned statement, the confession itself, would be inadmissible in the prosecution's case in chief because of the Miranda violation. But the gun itself, the physical fruit, might still be admissible, provided the initial unwarned statement wasn't actually coerced or involuntary. The Supreme Court has stated that the Miranda rule protects against compelled self-incrimination through testimony and doesn't automatically require suppression of physical evidence derived from a voluntary, albeit unwarned, statement.
Wow, that's a huge difference. So the physical evidence can potentially come in even if the initial statement violated Miranda, as long as there wasn't actual coercion making the statement involuntary. What about second confessions? If the first one was tainted by a Miranda violation, does that automatically make any subsequent confessions inadmissible, even if Miranda warnings are given properly the second time around?
No, not automatically. The Supreme Court has said a Miranda violation does not automatically require the suppression of incriminating statements made by the defendant after receiving Miranda warnings. However, there's a significant caveat here, especially relevant for bar exam essays. A second confession may be suppressed if the circumstances indicate that the substance of Miranda has been drained away by the initial violation. This often applies when police use a deliberate two-step question first, warn later tactic. If police intentionally interrogate without warnings to get an unwarned confession, that immediately give Miranda warnings and get the suspect to repeat the same confession again, courts may suppress the second confession too. They might find that the initial violation was so impactful and the warnings came so late that the warnings couldn't possibly have been effective in advising the suspect of their rights before they essentially confessed again. The key question is whether the warnings could function effectively under the circumstances.
Okay, we've thoroughly explored the Fourth and Fifth Amendments. Now let's shift gears to the Sixth Amendment right to counsel. This is another crucial protection for defendants, but it kicks in at very different stages than Miranda, and its implications are distinct. When exactly does the Sixth Amendment right attach? When does it start?
The Sixth Amendment right to counsel is offense-specific, meaning it applies to particular charges, and it automatically attaches when formal judicial proceedings have begun in any case in which actual or suspended incarceration is imposed. This is a key trigger point.